Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of land law, especially matters involving direction of Supreme Court to the authorities to pay the compensation to the landowners within 2 months for acquisition of land. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Revenue Divisional Officer and Another versus ISMAIL Bhai and others, pronounced on 22nd November 2022, the disputed land was acquired for extension of Nehru Zoological Park in 1981. Despite taking possession, award was not passed and no amount of compensation was paid. The landowners filed a writ petition before the Andhra Pradesh High Court, which was disposed directing the Revenue Department to pass an award within a period of 3 months. Only thereafter, award was passed and a meager compensation at the rate of ₹6 per square yard was awarded to the landowners. Later, the reference court enhanced the compensation to ₹250 per square yard with solatium and interest. The enhancement was questioned by the Revenue Department by filing appeals before the High Court. The landowners also filed an appeal questioning the adequacy of compensation. Thereafter, in the year 2017, appeal filed by the Revenue Department was allowed by High Court, reducing the compensation to ₹100 per square yard. Being aggrieved, the present appeals have been filed. The Supreme Court has held that the facts on record show that the acquisition of land was made in the year 1981. The land acquired is situated in a highly developed area of the Twin Cities, having amenities of water, electricity, drainage, telephone, transport, etc. Exhibits A2 and A3 are the decrees passed in two similar cases in which the compensation was fixed at the rate of ₹250 per square yard of the land acquired at the same time. The said documents find support from the testimony of PW1 and PW2. The evidence as produced by the landowners was not rebutted. On the contrary, the departmental witness admitted before the reference court that the acquired land of the village is a prominent area within the vicinity of the city of Hyderabad. In the absence of having any material on record, the reference court rightly relied on Exhibit A1, the sale deed of adjacent village Bahadurpur. Also, the letter of Revenue Department officer acknowledges minimum value at the rate of ₹200 per square yard on the date of acquisition. Therefore, the High Court erred in computing the compensation at the rate of ₹100 per square yard, ignoring the unrebuted documents produced by the landowners and without any cogent material on record by applying reverse calculation. As per the testimony of the departmental witness, the RW2, it is clear that the land acquired is near to the Agricultural University, National Police Academy and High Court of Andhra Pradesh. Considering the aforesaid and taking note of the date of acquisition, that is 1981, which is about 40 years ago, the value of the said land cannot be computed at the rate less than ₹250 per square yard, which is supported by the evidence brought on record by the landowners. Recently, in the case of Reddy Veerana versus State of Uttar Pradesh and others, reported in 2022 SEC Online 562, the deduction of the development charge was denied. The facts of the present case are not uncommon to the said case. Further, it is apparent that the land in the present case was acquired 40 years back in the year 1981 and the compensation was decided by the land acquisition officer after litigating in courts only at the rate of ₹6 per square yard. The land acquired is now in the heart of the city of Hyderabad, where the cost of the land has been increased more than 100 times. The development of the city has already taken place. The landowners whose land has been utilized 40 years back now cannot be compelled to pay the development charge for the development which has already taken place only for a parcel of land to which they have not given compensation up to decades. Therefore, the plea taken by the Revenue Department stands merit. Thus, the impugned judgment passed by the High Court stands set aside, restoring the order of the reference court. The amount of compensation as determined by the reference court be calculated and be paid now within 2 months.